Hi, and welcome everybody to this information session for the Animal Law and Policy Clinic. I'm Chris Green, Executive Director of the Brooks McCormick Jr. Animal Law and Policy Program at Harvard Law School. Today, we'll be hearing from our clinic director, Katherine Meyer. We're so incredibly fortunate to have Kathy directing the clinic, as she's been a remarkable mentor to many of our students as she prepares them to be both experienced attorneys and future leaders in the field. Indeed, many leading figures in the animal protection movement received their first training from Kathy at her firm Meyer Glitzenstein, including those at Lewis and Clark's Animal Law Litigation Clinic, Yale's Law, Animals, and Ethics Program, the Good Food Institute, Animal Welfare Institute, Animal Outlook, Rights for Animals, and the Humane Society of the United States. Quite an illustrious crew. This year, students are able to sign up for the Animal Law and Policy Clinic through the regular Helios registration, which begins tomorrow and runs for 1 day. So please join me in welcoming Animal Law and Policy Clinic Director, Katherine Meyer.
Am I speaking to people in cyberspace as
Both.
well? Yes.
Here and out there.
All right. Hello, everybody. Thanks for coming to this informational session. As Chris said, I have been, prior to coming to Harvard, I was in private practice for pretty much almost 30 years, doing a whole host of public interest kinds of mostly federal court cases, some state court practice as well, in a variety of fields, including environmental law, animal law, public health, open government, some constitutional law, and a smattering of other things, initiative and referendum laws, that kind of thing. And so I'm really a practicing attorney, which is what I bring to the clinic. So in the fall of 2019, Harvard started this brand new clinic, the Animal Law and Policy Clinic, and I was lucky enough to be asked to be its first director. So I helped launch the clinic a couple of years ago. And I just want to tell you a little bit about how we run the clinic, something about the seminar that accompanies the clinic, and talk about some of the projects we're working on, the pending projects, and then open it up for questions. And I have some students and a fellow here that can provide you real information, true story of what it's like to work in the clinic. I might have to leave the room for that. And they're also here just to heckle me, which is good. So basically the way we run this clinic is as a small public interest law firm. Gee, I wonder why. That's because that's what I know how to do. And I serve as the senior partner, basically. Our fellow, Kate Bartico, who's here, has been serving as our senior associate. And then all of the clinicians are our associates. And what we do is try to give you a real life experience of what it's like to practice animal law out there in the real world. And we construe our jurisdiction extremely broadly to include anything that has any impact on animals, wherever they may be, and whatever that may be. Including both animals in captivity and animals in the wild. And we do a lot of real life litigation and also a lot of policy work and some legislative work. And for every single project we do, we represent an actual client out there in the real world. And the students, I give the students a lot of responsibility. They might not like that because they have to spend a lot of time working in the clinic on these projects. They're the ones who meet with the clients. They're the ones who interview the clients, who meet with the experts, who draft the pleadings, who draft the briefs, who draft the declarations in support of Article 3 standing, etc. So if you want some actual real life experience getting out there and doing something good for the world and helping animals, this is the clinic for you. Even if you're not into animal law per se, if you want to learn how to litigate or otherwise advocate for a public interest, that's the kind of work that our clinic does, and we can teach you the skills that are necessary to do that kind of work. So we are seeking innovative ways in our clinic to use existing laws and extensions of existing laws to protect and advocate for animals. And what we do is for each project that a student is working on, the general setup is we give each student the responsibility to be lead counsel on a project, and then each student an opportunity to serve as co-counsel on the project. project. So not only do you learn how to take responsibility for a major project, but you also learn how to serve as co-counsel and work with the other counsel in the case. And I do not micromanage that relationship. Whatever works for those particular students is fine with me. And some students are, harder on their co-counsel than others. I'm not looking at you, Ben, when I say that. He's really been demanding as the lead counsel on his project, but it's working out well. We're going to get an outstanding project, I'm sure. So that's kind of how, and then I act as a supervisor, and Kate and I supervise the students on the projects, and we give you a lot of supervision. Again, I do expect the students to take on a lot of responsibility on their own, but I'm always available to review outlines of briefs, give you feedback on your writing, read your draft emails if you want me to, or if I want to the clients or the experts, that kind of thing. So I'm really available 24/7 pretty much. That's how you have to be in public interest practice. Okay, so that's the clinic, and then the seminar, which is an adjunct to the clinic. The first time you take the clinic, some people are repeat clinicians, and they don't have to repeat. They don't have to take the seminar again. We have one student, again, I won't mention any names, who for some strange reason is auditing the seminar again, because he really wants to learn this stuff. But the seminar is used to really teach you some substantive law in the area of animal law, but also really the sort of the skills that you will need, the issues that tend to come up all of the time, the kinds of pleadings if you're doing litigation that you're going to be faced with. For example, we spend a lot of time on Article 3 standing, because if you don't have standing to bring the case, you're never going to be heard on the merits. So that's a very rapidly evolving area of the law, which is, by the way, is in serious jeopardy given the current makeup of the Supreme Court, all of which we deal with in our seminar. And we also have guest speakers who are experts in their field. That's how we do the seminar. So I don't want to spend a lot of time on this. I did want to talk about some pending projects because I think that'll really give you an idea of the kind of thing we do and the scope of our jurisdiction. and then maybe we'll open it up to questions or hear what some of the students or Kate may want to say about the clinic. In no particular order, these are things that are pending right now. All right. When the new Biden-Harris administration came in, as soon as they came into office, we sent them a very detailed petition on behalf of a coalition of environmental groups, animal protection groups, and most importantly, climate change scientists from around the nation, the leading experts on climate change, asking the Biden administration to rescind a whole series of policies that had been put into place under the prior administration that basically prohibited the federal government from taking into account climate change in administering the Endangered Species Act. So we've asked the new administration to rescind those policies because obviously climate change is a huge problem for the environment and for animals and for humans, and if we don't do something about climate change soon, everything else we do is pretty much for naught, I will say. So that petition was filed in January, right after the new, literally, I think it was the second day after the inauguration, we got that out the door. There was a lot of press about it. Oh, that's another thing I want to mention. We do a lot of, because we're a public interest firm, we of course recognize the extreme importance of communications and media attention to our issues. And so we work very closely with Sarah Pickering, who is our communications manager. She's here. And we do press releases, talk to reporters when we file something or when there's an interesting development in one of our projects. We try to get that out because obviously public education about our issues is extremely important to helping animals out there. And the students handle all of that too. They're the ones who are quoted in the press. They're the ones who talk to the reporters. They help draft the press releases, etc. So the climate change petition is still pending. So far, we were surprised, but maybe we shouldn't have been that surprised that the new administration has not jumped on our idea and rescinded those policies. So those policies still remain in effect, and we may have to do something about that in the future. Stay tuned. We're also working on a case to improve the recovery plan for the grizzly bear. It's a threatened species under the Endangered Species Act. And our clients, our client, the Center for Biological Diversity, several years ago petitioned the Fish and Wildlife Service to amend the recovery plan to expand the habitat that the grizzly bear should have in order to recover. And the Fish and Wildlife Service declined to even consider the petition on the grounds that it was not a rulemaking petition within the meaning of the Administrative Procedure Act. That decision was upheld by the lower court, and it's now on appeal in the Ninth Circuit. And the Center for Biological Diversity is the plaintiff in that case. But our clinic did an amicus brief on behalf of a coalition of law professors around the country who are experts in both environmental law and administrative law. And we submitted an amicus brief explaining to the court why a recovery plan under the Endangered Species Act qualifies as a rule, which is very broadly defined in the Administrative Procedure Act, and therefore the Fish and Wildlife Service must respond to that petition. That case is being argued in the Ninth Circuit in Seattle on April 12th, and the students will be doing a moot court for the attorney who will be arguing that case, and hopefully also attending the argument virtually. So it'll be a real great experience for them to see how the moot court helps shape the argument and how it pans out in terms of how the actual argument goes. Another matter we have pending right now that Kate Barnico, our fellow, did most of the work on was a petition to the National Institutes of Health to redefine the term animal, which currently does not include invertebrates, including cephalopods like octopuses, squid, and cuttlefish, which certainly are animals, but they're not considered animals by the federal agency that doles out millions of dollars in federal research funding to experiment on these animals. And because they're not considered animals, they don't get any of the protections that animals get, including humane treatment during the time they are bred, maintained, and experimented on. So we're trying to get that changed. We also are involved in a huge piece of litigation out in the northern district of California involving the Thule elk, which is a species that used to be roam freely in the state of California. It was nearly extirpated many years ago, and pursuant to the congressional directive was reintroduced to a portion of a national seashore that is on a peninsula in Northern California. I don't know if any of you have ever been to the Point Reyes National Seashore. It's a beautiful, beautiful area. And there's a section of that seashore where they reintroduced the Thule elk, which was great, except for the fact that the National Park Service erected an 8-mile-long fence across the peninsula to keep the elk from going south of the peninsula, where they would get access to forage and water. And the reason they did that, there were some inholdings of some ranchers down there who have livestock ranches, and they don't like the elk competing for their food and forage, so their water and forage. So we have sued the National Park Service in an effort to have those management practices changed, and most urgently get much needed food and water to the Thule elk, who, because of the drought conditions in California, are dying of starvation and dehydration. We did a whole round of emergency injunction effort, which we were not successful at, and we are now on cross motions for summary judgment, which Kate again argued a few weeks ago, and we're waiting for a decision. We've got a case under the Poultry Products Inspection Act against the federal United States Department of Agriculture for denying a petition our clients, Animal Welfare Institute and Farm Sanctuary, submitted to require the humane handling of the more than 9 billion chickens and turkeys that are slaughtered every year for food. There's no current requirement that they be handled humanely. So that's a case that we won the motion to dismiss on standing, and we're now on the merits in that case. We're doing a big project on the Florida manatee. I can't describe the details of the project, but the Florida manatee is a threatened species that is in a dire situation out of Florida because of pollution and boat strikes and just loss of habitat, et cetera. And it's doing so poorly right now, it's actually starving from a lack of food, so much so that the Fish and Wildlife Service, for the first time in the history of the agency, maybe I might be exaggerating, but they never do this, has intervened and started giving them supplemental food, in stark contrast to what they refused to do for the federal government. So we've got that case, that project pending. We are doing a Freedom of Information Act case involving the data that importers and exporters of wildlife have to submit to the Fish and Wildlife Service in order to get permission to import and export wildlife. This is really important data because it helps groups monitor wildlife trafficking, which is a huge industry in the world right now. It helps these groups determine which species are most in need of protection under the Endangered Species Act or CITES, the International Treaty that protects these species. We filed the case a few months ago, and we've already received massive amount, voluminous data as a result of filing the case that shows how prevalent the import and export of wildlife is in this country. Put out a huge press release, which got some coverage. And that case is, we're proceeding, we're expecting more data as the case goes on. We have a case against the United States Department of Agriculture for failing to improve the standard for the psychological well-being of primates used in research. And that's a case, the first case we ever filed in the clinic when I started. And we have won every chapter so far, including a motion to dismiss also on Article 3 standings. We got that victory last fall, and we're on the merits in that case as well. There's another follow-up case, stay tuned, that will probably be filed later this week. We're also doing some CAFO work for some activists in Delaware who are trying to get information about permitting of CAFOs, concentrated animal feeding operations in the state of Delaware, and we're advising them about that. And we do quite a bit of work in the sort of alternative protein food space. We petitioned, the clinic petitioned the USDA, the Fish and Wildlife Service, a couple of semesters ago, to not issue any labeling requirements for these, non-dairy products that are called milk and butter and cheese and other things, but they're not dairy. And we submitted a very lengthy petition to the federal government explaining why they should not impose any kind of restrictive labeling requirements on this product so that we can have an equal playing field. The idea is, again, just to show you how broadly we construe our jurisdiction, is to transition away from animal-based products to non-animal-based products. And we also have We also have a project pending where we're trying to change the listing, the rule that governs the listing of the Canada lynx, which is a threatened species. And when the Fish and Wildlife Service listed the lynx as threatened, it carved out an exception for the captive members of the species, which get no protection under the Endangered Species Act. And captive lynx are used in zoos, roadside zoos, and other kinds of exhibitions, and they get no protection. So we have petitioned the agency to change that so that we can get them the protection that they deserve. I think that's enough for now. We've got a lot going on. It's a pretty demanding clinic, I won't lie. Maybe this is a good segue to the students. You may want to say something. Why not?
Maybe start with Kate.
Sure.
Please speak in the mic so the people on.
Kate has been our fellow for years now.
Almost. What would you like me to say, Ken?
Whatever you want to say. I will listen.
I'll give a little bit of background for myself. I graduated from HLS in 2019, and I came here not knowing animal law was a thing. I got very lucky falling into the program, which is obviously much newer at the time, and did a number of internships and externships with animal protection organizations. I gave Chris a little bit of feedback that the clinic never got opened while I was a student. So I was lucky enough to come back as the inaugural clinical fellow. So I've been here 3 years helping Kathy out and the students out with a number of different projects. I mean, it's been just an invaluable experience. I want to continue this work and litigate. There's really no one better if you want to learn and work in the animal and environmental space. There's no one better to learn from than Kathy. And even if this isn't the exact field that you want to work in, you're going to get real hands-on experience that I've heard from other students. I took clinics when I was a student here as well. You're just not going to get the same kind of experience that you get here. So I'm happy to chat with anybody about your experience as a law student, the field generally, anything I can.
Hello. I don't know that I have all that much to add, given what Kate and Kathy have shared. I'll just say that I'm a 2L. I came to law school kind of aware of a biodiversity crisis, and I wanted to know how I could use my education to help make that better. And in the clinic, I found a really great way to do that. Since my first semester as a clinical fellow, or not fellow, associate, last semester, I've kind of become like a lifer. Like I'll be in the clinic my next 2 semesters too. Like I'm stuck.
Oh, great. I'm gonna hold you to that.
You can.
Writing it down.
You're allowed to. What I really like about the clinic is that, as I'm sure a lot of you are aware, there's an environmental law clinic as well. I'm somebody who's interested in environmental issues, so I didn't really know as an incoming student what the difference was between the two. And I'll just say that if you're curious or confused about it, what I found is that the clinic is a really great way to advocate for natural resources issues that I care about that have an animal connection. So if you maybe are interested in things that have a connection to wildlife, I would highly recommend the animal law clinic. But there are also things that the clinic does that aren't so directly related to like wildlife. So obviously there's a lot of work related to captive animals and farmed animals. We've done comments to administrative agencies on, like Kathy mentioned, food labeling. So what I would say is that, one, it's a great environment. It's very warm and welcoming. Kathy is a very funny person, and her seminars are very fun. I would also say that the clinic is kind of a choose your own adventure. Like there's so many different options that for somebody like me who really cares about wildlife, and that's basically the reason I went to law school, like I can kind of just work on that. And if there are other students in the clinic who are basically just into like captive animal issues, and they've been able to just work on that. So there's so much like choice and discretion given to students that are participating in the clinic, which has made it a great experience. And the last thing I'll add is that it's been excellent in terms of kind of skills acquisition, like really practical, useful stuff. Obviously, Kathy is a highly experienced litigator, and you're going to get the most knowledgeable kind of insight about the different decisions and situations you might confront in your time in the clinic. But also, I've been able to work, so Kathy mentioned the FOIA litigation that we're on right now. So I've been able to work in this really fast-paced lawsuit that we filed against the government and is actively producing beneficial results for our clients. So I think that is especially a great example of how the clinic is a way for students to get litigating experience really early in their careers, which is a benefit, of public interest law, and this really makes good on it. So I would say that if that's something that you're interested in, a high degree of autonomy, experience with complex issues, and agency over your projects, this is a great place to do it.
Kathy, can you talk a little bit about how the students can kind of have input on which cases they work on or projects?
Yes. So the way I do it every semester at the beginning of the semester is I go through what's pending that needs to be worked on that semester, and then what's in the hopper, what are the new projects that we need to work on. And I describe them, and then I let the students, I give them a little rating chart, I send it out to them, and I say, let me know your preferences. And so the students rate what they want to work on from 1 to 5, 5 being the thing they're most interested in, 1 being the thing they really don't want to work on. And I give them an opportunity to comment on what their selections are and what they really don't want to work on. And then based on that, I try to match, as I said, someone who's going to be the lead attorney on the project, and then someone who's going to be co-counsel on the project. And it's worked out pretty well in terms of matching people with their project. I haven't had any situation where somebody had to work on something they really didn't want to work on. So that's not fun for any of us. It's not fun for me either. So far so good on that score.
Okay, anyone else like to add any comments? Great.
I just have a question. Sure. So with registration and mine coming up, I had heard from a different clinic that there are fewer spots in the spring because people who choose to stay on from the fall are given first priority. Is there a similar thing here? Is there any difference between fall and spring? Is it easier to get placed in the fall?
That's a really good question. Up until now, we've had, we did it by application. So now we're doing just open enrollment. So I don't really have a way to gauge that. You know, we have so much work to do that I don't think you have to worry about, you know, getting kicked, not being accepted to the clinic because somebody else wants to stay on. We have had many repeat clinicians. I mean, I've had students who took it all 4 semesters. I mean, that was open, you know, up until now. And apparently Ben is going to be taking it for every semester too. So I mean, you get invested in projects is what happens, and especially litigation. Any of you who come into the clinic and get involved in litigation will quickly learn. This is probably no surprise to you. Litigation tends to go on and on and on, and there are many different chapters. And so, you know, students get invested in what they're working on and they get into it, and they want to stay on. So the short answer is no. There's not going to be any difference, any less spots, I don't think, depending on which semester you want to take it. However, if you're going to become a 3-owl and you're thinking about taking it, I would recommend you take it in the fall semester because you might really like it and really like what you're working on and want to continue working on those projects. And then you could do that for the spring semester as well.
Just to add on to that too, thinking back on my law school experience and the internships and externships I had, you know, over the summer for 3 months, I did some during the semester as well. Even though that sort of feels like a, you know, a full semester or even 2 semesters, as Kathy said, in terms of litigation or other projects, it's really not that much time. So one of the most valuable things that I've had since graduating and working is being able to see these projects long-term, and you learn a lot more in terms of strategy rather than just redlining a brief or something like that. So I would suggest if it's something you're interested in, getting in as soon as you can, because it's quite likely that you want to continue, and that will not just improve your experience and the things you learn over a sort of just in terms of volume, but it has a cumulative effect as well.
So you mentioned that the workload is pretty intense. So not that that's deterring me, but would you talk a little bit about that? Just expand on that a little bit.
Sure. Well, you could take the clinic for either 2 credits up to 5 credits.
3 to 5.
Oh, 3 is, I thought you could take it for 2.
I think all clinics have to be at least 3.
Is it 3? Okay.
I think that's the first time when you're doing the seminar. I think after that, isn't it the case?
I thought I had some 2 creditors. I'm pretty sure I had them in the past. In any event, up to 5 credits, and each credit is supposed to translate to 4 hours of work. So if you can do the math, figure out what that means. I try consciously to make sure that those who are taking it for more credits get more of the work burden than those taking it for less credit. So I take that into account when I make the assignments, and in terms of what I actually ask you to do within your project. So, I mean, that's really how it works. You have to keep track of your hours, and you know, everybody's pretty much on the honor system. I do see that the timesheets at the end of the semester. But you know, again, you're working for real clients that have real demands, and so sometimes it takes longer than you think it's going to take. But I do take all of that into account. And also, if it's a really huge project, I assign more students to it. For example, this managing project I haven't been able to describe in detail because it's still subject to a privilege. We've got 4 students working on that right now because it's a huge amount of work. And even with that, it's a huge amount of work. Does that answer your question?
Yeah, thank you.
Any other questions? Yeah.
I'm sorry if this got asked already, but how many students do you take each semester? Do you have a cap on?
That's a great question. So far, we've sort of been around the 5 to 6. It's a relatively new clinic, so there's been 5 to 6 students in it per semester. But now that we're opening it up to everyone can sign up, you know, we anticipate hopefully there'll be more students taking it. I don't think we've set a cap yet.
I think we said 15 for initially, but we'll see how that goes.
Chris has set a cap at 15. I don't know what he's expecting
I
us to
actually
do. but-
cleared that with Kathy, but that's,
So it's been pretty small so far, but we want as many students as we can get because we have so many things to do. And I mean, that list I gave you, that's a partial list. And that doesn't include things that are on the immediate horizon, which I can't go into now. There's a lot of projects that a lot of time to take, so the more students, the better.
and as far as like the sort of student experience as well, we had a former student, Rebecca Garverman, who worked on an amicus related to Pacific walrus, which depends on sea ice for its entire existence. And yet when the Fish and Wildlife Service was making a determination as to the future viability of that animal, they chose not to adequately take into account climate change, which obviously is impacting sea ice. And so the clinic submitted an amicus, and during the oral arguments for that case, which the students were watching, it was during the COVID year, one of the Ninth Circuit judges actually directly quoted a line from the amicus that Rebecca had written herself. So here she is sitting back here in Cambridge and watching this and hearing her own words come out of the mouth of a Ninth Circuit Court of Appeals judge. It was really, she said it was the single high point of her entire law school experience. So it just gives an example of some of the.
Yeah, she did a great job on that project. That was an amicus brief that we did on behalf of the nation's leading climate experts, walrus and climate experts. So she got to work with. She's very interested in science, so she got to work on that, science and the law. We do a lot. There's a lot of science involved. If that's what you want to do, I do meet with each of the students that sign up for the clinic before it starts to get a sense of who you are, introduce myself, get a sense of who you are, your strengths and weaknesses, your life experiences, so that I can just get to know you, but also take that into account as well when assigning projects. And also matching you with co-casting. I try to take personality and all of that to cap decide who you work well with.
Any other questions or comments?
Caroline, come on, she took the clinic. Let her say something.
Hello, I took the clinic for 2 semesters. I guess I'll just add, I think this is coming through, but like, I think Kathy really cares about each of the students in the clinic and their like your personal development. And I think you'll really build skills as a lawyer that you don't build in a normal class in law school. And you know, like you have your own clients, you have a lot of responsibility, and it's just a really, really valuable experience, I think. And I'm happy to answer any questions too if you're not sold on the clinic yet.
I'll just quickly add, after Chris's comments about Rebecca, is that, and what Kathy said about media, is that students are really explicitly elevated by the clinic. And whenever, for instance, our FOIA case, when it was filed in the fall, Caroline was my lead counsel. Her quote was published in the media. This semester, when we started getting results from our litigation, I got to have some quotes of mine placed in some major news publications. I think E&E News carried our press release. The Hill ended up doing a story about it. And of course, our clients put out a press release. So I will say that the clinic does a lot of work to elevate and honor the labor that the student clinicians put in.
Just to add a little bit more to the media element and the clinic overall, I mean, Kathy is not only so experienced in her field, I think I've sat in on some of the seminars because you're really learning from somebody who's actually done this and has been a practitioner for years in the field, and she is not just experienced but fun to have as a mentor. There's so many cases, so many impactful cases. It's relatively easy to get at least some media coverage, but we've had incredibly high-end media coverage from Newsweek to the BBC to CNN to Los Angeles Times, Boston Globe, New York Times. And I think that's a very unique opportunity as a student to get some guidance from me as well on how to take that kind of interview and to get that kind of coverage. These sorts of things, working on an actual case and being quoted, in national news media are pretty invaluable to one's resume and life experience, and something that you can talk about when you're eventually pitching yourself for a job. So I would highly recommend the clinic.
And Sarah does conduct media trainings for our students as well to help them get up to speed with that.
Can I add something? I just want to say that no one has said this yet, but I think this may be something that really interests you, which is because you're working with actual clients in the field, they get to know you. If you want a job in this field, and again, broadly speaking, environmental law, animal law, if you're looking to make that your career or looking to work in that field just for a short period of time before you do something else, this is a great place to be because you're meeting, I mean, we represent the national environmental organizations, the national animal protection, welfare, animal rights organizations. They are our clients. And so they work with you and they come to love your work. They think you're great. And then you want to go work for them, you're high on the list of people they're going to consider. I mean, Ben has been working for the Center for Biological Diversity in the clinic, and now he's already lined up a job for the summer with them. They love him. So in terms of how this might pan out for your future, it's a really great way to meet these organizations and show them your work and hopefully maybe parlay that into a job in the future.
From what I understand, there was actually competition within CBD among different groups, practice
Yeah,
groups
they
who
were
would actually
vying
get
for
to
him.
have Ben work with him this
They
summer. For
were
real.
vying for him. It's true.
I was just gonna add another point on media. I mentioned how wonderful it is to learn from Kathy. The same is true for Sarah. My position here is up in August, and so I'm currently on the job market. And in just yesterday, in 2 separate interviews, I was asked specifically about my media experience, not just my litigation experience. And
Right.
the fact that I've had that training from Sarah at this point, clearly quite impressed with that. So.
She's learned what to say and what not to say. Kate had an argument in the Elk case recently, and our clients were concerned about how it went with the judge, and they wanted to lambaste the judge. Can we start lambasting the judge in the media? And we were like, no, that's not a good idea. We don't want to be saying nasty things about the judge in the media.
Especially before they decide.
So, I mean, that's a really important part of the media training is how to get your great soundbite out there, but also what to say and what not to say, and what to be cognizant of in terms of those reporters are trying to get out of you. Sarah's really good at that.
And Kate did an amazing job doing the oral argument for the
yeah.
case, and we had 2 separate moots before that, and it was really fantastic for me to just see how valuable that input was. There were some really great points that got brought up that just when the actual argument happened, you could see how Kate had just slightly molded her argumentation on the basis of some of that feedback, and it really was much stronger. And Sarah, how many pieces of media coverage do you think there have been over the Elk case? Well,
At least 25.
yeah, several dozen in major media outlets.
And this is a really great point because, public interest advocacy, you don't always win your cases, but if you do media on them with public education, you can move the ball forward. For example, it's only because of all the media attention that we've gotten in the elk case that the National Park Service started giving the elk supplemental water. They weren't doing that at all. Now they're putting out troughs in this area of Point Reyes National Seashore. And it's because of the pressure that they were getting from the media. And the media in turn was generated because of our efforts and the efforts of our clients out there, being activists in the field.
And not only that, they had actually removed troughs that the public had put out there previously. So, yeah. Any other questions or comments? Kevin, can you talk about a bit about the black bear case? That was a nice victory of the clinic. The black bear where the
Oh, the black bear, the New Jersey bear hunt. Yeah, that's a great example. We were asked by a former U.S. Senator from New Jersey who just to figure out a way to end the annual bear hunt in New Jersey. And this required an analysis of the New Jersey state constitution, the way it was, the entity that's responsible for authorizing the bear hunt was constituted, looked like it was a little fishy there, under the constitution, and did an analysis under the existing law. And we did this huge memo, which our client, which was this U.S. Senator, then forwarded to New Jersey Governor Murphy, who, based on our analysis, and I'm sure there were some other concerns, but based in part on our analysis, canceled the bear hunt.
Happening for
Forgot about
years.
that one. Got any other ones you want to mention?
Well, I will say it's going back to the cultivated meat issue. We had a former student, Kelly McGill, who is very interested in these issues and currently working for the Good Food Institute. She took the lead on drafting this. So we had held I'd attended a couple conferences early on, like the first cellular agriculture conference back in 2016. And I noticed how nobody was really talking about regulatory issues. When I would ask them about them, I would either get a dirty look or a blank stare. The dirty look folks were like, hey, shut your mouth. There's donors here, or there's investors here. We're trying to raise capital. We don't want to hint that there might be some potential roadblocks. The blank stare folks were more like, oh, there's a bunch of smart lawyers out there that I'm sure we'll figure this out down the road. It's nothing to, I mean, I'm a business person or I'm a scientist. That'll get worked out by the lawyers. But then I would bring up the example of genetically modified salmon, which literally from the very first FDA filing to actually first selling to market was 27 years. So you imagine you're an investor in a cultivated meat company that invents, that designs the perfect cultivated chicken nugget, and you're not allowed to sell your first one 27 years later. So we held a roundtable. We convened a roundtable here. One great thing that another value that Harvard has is the ability to convene. So we convened a closed door roundtable that had the heads of several of these companies. And we viewed this as a collective problem as well. We were also a little worried that there might be some, as competition grew among these companies, that one of them might try to kind of rush through the regulatory door a little unprepared, sort of a Leroy Jenkins effect, and cause problems. That was more of a collective concern. So we had the heads of several companies. We had several of the top scientists, including Mark Post, who created the world's first cultivated hamburger. We had some folks from the advocacy side, from the Good Food Institute, Bruce and Jessica Almy, who's also a former mentee of Katherine Meyer. And we had, even several former FDA lawyers and even former Secretary of Agriculture weighing in on this. And out of that, we charted a kind of assessed the landscape and charted a course for how we thought that the two agencies, FDA and USDA, should split up, allocate the jurisdiction for these products between the two of them. And and then basically what the government decided to do, the two agencies, was pretty much verbatim what we had recommended. So once it was determined that the USDA's Food Safety Inspection Service would have labeling jurisdiction, there was concern that among some, that the USDA might be a little too close to the traditional slaughtered meat companies and might try to be a little overly restrictive. So our student Kelly McGill, working in the clinic, wrote this 20-page letter, which was treated like a formal petition for rulemaking. And so they responded saying, we received your petition and we'll take this under advisement. And then that was in 2020. And then last September, the USDA put out a advance notice of proposed rulemaking seeking public comment on these issues. And there, in the Federal Register, there's a whole paragraph with that has the heading Harvard Animal Law and Policy Clinic. And they speak and they wrote us directly and said, we are doing this directly in response to the formal petition for rulemaking that we received from the clinic. So, and now that Kelly is working at the Good Food Institute, it's funny how, this has been such a major step in that whole field, and that not everyone there, and like slowly more of her colleagues will find out that she's the one who drafted that, and then she gets this sort of amazing status there. But it just does show you as a student what a massive impact. I mean, this is an industry that has the potential to affect billions and billions of animals' lives by replacing with better products. And so even as a student, you can have a really huge impact.
Absolutely. The other thing I forgot to mention, if it matters to you all, is we've had a fairly robust Supreme Court practice already too. We filed a cert petition involving CAFOs and a right to farm statute, which we believe was unconstitutional. A couple of semesters ago, the cert petition was denied, but that was a project that students worked on. We worked on a FOIA, Freedom of Information Act case that was pending in the Supreme Court, and we wrote an advocacy group in that case. And there's probably one on the horizon now that the Prop 12 matter has been taken up by the Supreme Court. So if you're interested in Supreme Court practice, it's another reason to take it.
One other thing I would like to add related to that is that we are in 2018, our fellow Ann Linder prepared a report on what was called the King Amendment. It was an amendment to the U.S. Farm Bill called the Protect the Interstate Commerce Act that essentially, because even though King was a big states' rights Republican, because the largest egg producer was in the country was in his district, he inserted this language that would prevent states such as California and others from setting their own animal welfare standards and having those apply to out-of-state producers that want to sell into their state, which is the fundamental issue in the Prop 12 litigation. So we now are pivoting, given yesterday's news that the Supreme Court has taken up certiorari and granted certiorari in this case. We're going to be pivoting that on a much more accelerated schedule. We have a new fellow, Kelsey Everly, who is going to be updating the King Amendment report in advance of the EATS Act, which is basically taken verbatim the King Amendment and reintroduced as standalone legislation, again, by the two senators in Iowa. So we will be looking for student research assistants. So if there's any of you who would like to get a jump start on some of this work, we're going to be putting something in the administrative update section, and we'll have it added to the Animal Law Society newsletter as well. But we are going to be actively looking for several student RAs to help work on this project because we are on a much more accelerated timeline.
Speaking of RAs, I'm going to need a research assistant for the summer too. So put something out on that. If anyone's interested in applying for that.
Well, she would probably not like to hear this, but literally doing the math as I've done on this a few times, like I don't think there is a single more experienced animal protection litigator in not only the country but the world than Katherine Meyer, and we are very, very, and I defy someone to name somebody else. We are so fortunate to have her here and very grateful to have her here. So please join me in thanking her for today's session.